This is case number 18-240566. This is Sabrina Braswell versus Dennis Cleveland. The matter is before the court, set on for a motion hearing. The motion is to reopen the matter after bankruptcy, it appears. They're also, I'll strike that. Your appearance for the plaintiff in this matter, counsel.
Good morning, Your Honor. May it please the court. Gad Holland, appearing on behalf of Sabrina Braswell.
All right, your P number, if you will, for the record, Mr. Holland, please.
266, yes, Your Honor. 26655.
All right, thank you, Mr. Holland, and good morning to you. For defendant
Good
in
morning,
this matter, Dennis Cleveland, please. For defendant, Dennis Cleveland, do I have counsel look like Scanlon? Mr. Holland, have you spoken with anybody from that side today, sir?
No, I have not, Your Honor.
So this looks like your motion to reopen the matter, and it looks like this is after closure for bankruptcy purposes. Is that correct, counsel?
Yes, Your Honor. Following the adversary proceeding in the United States Bankruptcy Court before drawing a blank, the judgment was entered in the amount of, the judgment was entered in the amount of $15,000 on June 15, 2022. I'm sorry, I got it now. Judge Randon.
Got it. So, and I'm looking at the motion that you filed, and that portion of the claim that you brought herein was found to be non-dischargeable to the tune of $15,000. Is that correct, sir?
Yes, Your Honor.
All right. On the basis that's set forth herein, I will set aside the closure of this matter and reopen the file. I also see that you submitted a second amended complaint that you wish the court to consider. Is that correct, sir?
No, Your Honor. That's moot now.
Yeah, and that's what I was getting at. I thought that you were bringing something else into the scenario, and so the court, on your representation, the court will regard the second amended complaint as withdrawn. The application for the same is withdrawn. All right. It appears the other side has not appeared on this matter. The finding it in bankruptcy court. The court is constrained now to consider your application, I believe, for entry of judgment, given that the other side is not here. Is that correct, counsel?
Yes, Your Honor.
All right. So the court will enter judgment for the sum of $15,000 as allowed by the bankruptcy court as a limitation, and will sign a order upon presentment to the court. And counsel, you can present that order through email. I'm going to give you an email address where you can send it to, and we'll get it entered right away. That order should, of course, have with it a provision that says that the matter was reinstated by this court or reopened by this
Yes, Your Honor.
Judgment presented.
Yes.
That address is Latifah, LATIFAH dot, the last name is Hunter, HUNTER, at 3636th 36 District Court.org.
Yes, Your Honor.
Thank you, counsel. Good day to you.
Thank you, Your Honor.
The court now calls case number 21-153-543. This is Integrated MRI Center doing business as Complete Imaging versus City of Detroit. The matter is before the court regarding an adjourned date of hearing. I think I sent this over for a review. Your appearance for the plaintiff regarding this matter, please. For defendant, City of Detroit.
Good morning, Your Honor. Charlotte Bennett here on behalf of City of Detroit. P number 85699.
All right, thank you, Madam Council. Good to see you again. Good morning to you.
You as well.
So kind of update me on, well, I see Mr. Cordy on here. No, this is not his office. Have you talked with the other side at all this morning regarding this matter?
I have not, Your Honor, and I know that it's set on, at least on the calendar, it looks like as a hearing. I'm not entirely sure what we're here for today, because I think the one motion that we had was a motion to dismiss in lieu of answer, and we got that worked out with you, I think back in May. So, yeah, so I don't know if they are going to appear this morning, just because I don't know that they think anything's on.
Got it. I do see that there was a stipulated order compelling responses to discovery.
There was.
Taken up on the 17th, the 19th of September. All right.
Yes.
So in terms of the underlying case, the status of things, I suppose the case is moving forward with discovery or offers, or what? It seems to be on a normal track.
It is on a normal track, I would say, Your Honor. The stipulated order compelling the discovery responses had a due date of yesterday. I know with that being a federal holiday, I don't know if plaintiff is a little delayed on that, but we are waiting for their responses still. So hopefully we get those here today and we can review them. Once discovery's been reviewed, I'm hoping we can move forward with some settlement negotiations in this matter and get it wrapped up.
So I'm gonna go ahead and then adjourn it. Good cause found. How much time do you think the court should maybe engage on this again?
I think a 60-day adjournment would probably be enough for us to review that discovery, make sure we have what we need, and then get with plaintiff's counsel on seeing if we can wrap it up.
All right. I'll go ahead and set it over.
12/14.
December 14, 2022 will be the next action date in this matter. I'll set that as a final pretrial conference.
Okay. What time, Your Honor?
That's going to be at 9:30 a.m.
9:30.
9:30 a.m.
Okay, that works for us.
Thank you, Madam Council. Good day to you.
You as well.
The court now is called in case number 22-177892. This is biomolecular integrations et al. Versus State Farm Mutual Automobile Insurance Company. Today's date and time set for a motion for summary disposition, a hearing on the same. Your appearance at this time for plaintiff.
Yes, good morning, Your Honor. Connor Flaherty, P84485, appearing on behalf of the plaintiffs.
All right, thank you, Counsel. Good morning to you, sir.
Good morning.
For defendant State Farm Mutual Insurance Company, your appearance at this time.
Good morning, Your Honor. Ashley Van Dyke for defendant State Farm, P84322.
All right, thank you. Good morning to you, Madam Counsel. All right, I see that this is defendant's motion for summary disposition regarding this matter. And so I do see the response, plaintiff's response to the same, and somehow it looks like maybe the motion has gotten away from the file for some reason. But go ahead, Madam Counsel. Go ahead and tell me about your motion, if you will. I looked at it on a previous occasion, so I'm trying to figure out where I put it. Go ahead, Madam Counsel.
No worries, Your Honor. I'll give you a good summary. Essentially, we're asking for an MSD based on the fact that the patient, or in our case, the claimant, Kimberly Smith, failed to appear on 3 separate occasions for an examination under oath. She also failed to appear on 3 separate occasions for an independent medical examination. So we're filing this under 3151, which is when a mental or physical condition of a person is material to a claim, that person shall submit to a physical exam, which again, she's failed to do on several occasions. This under 3153 gives the court the authorization to dismiss the party's failure to submit to an IME. And then under TBCI PC versus State Farm, it's well established that a provider claiming no-fault benefits for medical services provided to an insured stands in the shoes of the insured. A provider's entitlement to no-fault benefits is directly dependent on the insured's entitlement to benefits. And considering Ms. Smith has failed to appear to all IMEs and with plaintiff standing in the shoes of the insured, it is our position, Your Honor, that the plaintiff won't be able to make their claim without the plaintiff, and State Farm will be prejudiced by not having the opportunity to perform those EUOs or IMEs. I also would like to point off in Brother Counsel's brief, they recited a case of Robert v. Farmers in which they stated the court held that a missing an IME doesn't irrevocably deny a claimant ability to recover benefits. Rather, benefits are suspended pending an IME. I read that case, Your Honor, and unfortunately that is a false citation of that case. What the court did state was they were citing Farmers, which they put, and I'll just read into the record, Farmers did not conclude that because, yeah.
Let me stop. And you can read it in the record, but once you start reading, we tend to speed up. So I'm just gonna ask that you take the time reading it so the court reporter can actually take it. Okay, all right.
Yes, Your Honor. So in that matter, the court said Farmers did not conclude that because of Underwood's breach, benefits were irrevocably denied. Rather, it merely suspended those benefits until Underwood paid a $1,000 cancellation fee and submitted to a psychological exam. In this case, they were citing Farmers' policy, which said Farmers had put that they had the right to suspend any PIP benefits pending an IME when someone chooses not to go. In this case, the Court of Appeals reversed and found for Farmers in this matter, which contradicts what plaintiff's counsel has stated. So again, we just like to state that plaintiff in this matter stands in the shoes of the insured, and the insured has been more than uncooperative. And with that being said, we respectfully ask for MSD in this matter, Your Honor. Thank you.
All right. And how many times did you schedule the IME?
3 times, Your Honor. On May 12th of 21, May 17 of 21, and June 21 of 21.
Any reasons or any statements of disability, inability to attend any of those ever been brought forth as a justification for the same?
No, Your Honor.
All right, Ms. Coleman.
Yes, good morning, Your Honor. In response, I would simply direct the court to 3151, which I have cited in my brief. And what defense is asking for is this honorable court to punish my client, a party to this suit, for the non-cooperation of a non-party to the suit. 3151 punishes a party, it punishes a plaintiff for disobedience. It is very clear, it's very repetitive on that point. And my client has done nothing but cooperate in this litigation. They have made every effort to submit their claims to the defendant. The defendant has refused to pay. If defense's position is that they could not get IMEs done, they could have easily submitted records to an IME doctor, had the IME doctor do an independent medical exam through those records. They elected to not do that. Further, if their point is that they need an EUO, I don't think sister counsel subpoenaed the claimant to try to get her testimony as to what happened in this case. I didn't see a subpoena filed. If she did, I'd like to see it, but she never did that. So now what defendant's trying to do is use a back door to get this whole case kicked. And my client has done nothing wrong other than treat a woman who needed medical treatment. And it seems, I mean, almost unfair and unjust that they would try to do that. What's the incentive for medical providers to give treatment to people who have accident-related injuries, and then they're at risk of having their whole claim thrown out the window because that patient decided not to cooperate with their insurance company. And why would providers get assignments and be able to have their own independent cause of action if the whole case can get kicked because of that non-cooperation, the non-cooperation of the non-party? So that is what I'd like to add to my brief. I'd also rely on my brief in terms of what Sister Council's talking about with Roberts. I'd like to be able to look at that more closely. I mean, one of the things that was decided in that is that non-cooperation is by itself not enough to get the case kicked if they can eventually get an IME. If they're blatantly and wantonly refusing to participate, then that is when a dismissal can be used against a party. If you had issued an order compelling my client to do something and my client decided, you know what, I don't care what the judge says, I'm just going to do whatever I want, then Judge, that would be, you dismissing the case would be a very warranted action. But that's not what's occurring here. So I would respectfully request this honorable court deny the motion for summary disposition.
Well, let me just point out the statute in such cases that relates to the cooperation of the underlying claimant does not predicate the consequences on whether or not it has been a judicial officer who has made a determination or issued a order of subpoena or directive for a underlying claimant to do anything. It seems that the statute places the onus and the responsibility on a claimant to participate and cooperate with the system that has been put in place. And upon receiving notice for such cooperation, such as an IME or even an EUO, that the claimant has to respond to the same. But significant to this case, and you make a very meaningful, heartfelt, and good argument as it relates to, is it fair? Does it make sense for a party who has incurred damages in an effort to help an underlying claimant who approaches them to lose their claim to recover because of the lack of cooperation on that person's part? Well, of course, that's not fair, it's not reasonable, it makes sense. But then their right to recover still lies with the underlying claimant. This issue of being able to recover directly from the insurer is up to this time, it seems to me, is still predicated. It's predicated on the nature of the claim. That is a derivative claim that you cannot detach the claim from the underlying claimant, and the statute as it exists at the present time doesn't allow you to detach from the underlying claimant's behavior. So that's a concern here. Let me hear from Ms. Van Dyke again. I'll come back to you, Ms. Florida, and then we'll finish out in just a second. Ma'am, anything you wanted to add at this time?
No, and brother counsel makes good arguments, but again, if it wasn't for the claimant, they wouldn't have a claim. And we have the right to see if their claim in this matter relates to the motor vehicle accident, which neither of us can do without Mrs. Smith, Your Honor.
What of the position taken by counsel that you have to exhaust other means when you cannot get to IME, otherwise you cannot proceed under the statute, i.e. take the medical records and submit them to a doctor for independent medical examination as a predicate before you can bring this motion to counsel?
Your Honor, we have no way of knowing where to even get medical records from because she hasn't submitted anything to either us or to our client State Farm. A lot of the times where we get different places they've treated, different places to get medical records is from these examinations under oath where they've stated where they've had previous existing conditions, where they've been treated, who they've been seeing. None of that's been done. None of that's been given. So we don't even know where to get medical records from, Your Honor, to even, I guess, help their case.
In your review and research as it relates to the statute cited in herein 53153, Have you been able to see any condition that requires uh, that you use a paper IME, if you will? If the defendant doesn't show up, that you have to exhaust other methods before you can move forward on a motion for some disposition.
I did not, Your Honor, no.
Counsel, have you seen, Mr. Corey, have you seen anything in the statute that would require? I've heard your argument from fairness. Have you seen anything in the statute that require that defendant exhaust other possible scenarios and remedies before they can proceed with a dispositive motion, sir?
Your Honor, I have not seen any statutory authority as to that issue. However, I would say in practice, that is something that does happen often, where an insurance company will look at records when they're having difficulty in getting an underlying claimant or getting a party. So there may not be statutory authority, but I would say there is a practice among insurance companies to do that. A custom, if you will.
Anything else, Ms. Corey, you wanted to bring to my attention? As I'm going to go back to counsel, she'll have the last word. Anything else you wanted to address, sir?
Yes, Your Honor. I would just again re-emphasize if maybe I didn't make this. I just want to make sure I make this very clear in terms of that dismissal is something that is really a last resort. It is it's the harshest thing the court can do to a party. And I'm just asking the court to please bear that in mind. And I know, Your Honor, that you're you to be a fair judge. And I just want to make sure that that's made for the record.
Thank you, counsel. You get the last word, Madam Counsel.
Yeah, Your Honor, again, I would just state one more time that State Farm has no way of gathering the information to defend this case. Then there's no way to tie the treatment to the alleged motor vehicle accident. The treatment didn't even occur until a month after the accident. Again, she's failed to not just go to the 3 IMEs, but the 3 EUOs from a time frame of the beginning of February of 2021 to the end of June of 2021. So we've given her substantial amount of time. And I understand that brother counsel doesn't think this is fair, and maybe it isn't. But I mean, ultimately, it's also not fair to our client to hold the burden of trying to provide them with proof for their cause. And ultimately, plaintiff does still have the recourse of going to Ms. Smith for not cooperating to recover those fees.
All right, I've listened to the argument on the motion for summary disposition. It sounds in challenging the plaintiff's claim based upon the failure of the underlying claimant to participate pursuant to 531.53 in a independent medical examination or an EUO in regard to this claim. It's been brought to my attention by these arguments that on 3 separate occasions the underlying claimant refused to participate in the same, and that has left the defendants in this matter in a position where they're unable to proceed going forward with the claim. Counsel for defendant, for plaintiff in this matter, has pointed out that there may be some savings tactics or approaches that could be used to acquire the information, and that dismissal is a hard and difficult approach to this particular matter. It seems to me that that to the extent that the underlying claimant refuses to participate, and to the extent that the statute places the defendants, plaintiffs in the position of the underlying claimant, that the underlying claimant has shut the door on the plaintiff's ability to go forward on this claim at this time. I don't know. It seems to me that the case that the parties were bantering over a bit really kind of addresses the challenge of what happens if the defendant decides to participate. I should say the underlying claimant decides to participate in the IME after the matter brought to court after there has been some effort to seek summary disposition. It seems that there may be there may have been some thought in those cases about how you save this from ultimate dismissal. In this case that's now before the court, there doesn't seem to be anything that suggested impetus on the part of the underlying claimant to participate. So that even if we're looking today to say, well, maybe this claim could survive because the underlying claimant has indicated that maybe she'll participate, maybe she'll come forward, and maybe she's received notification from the plaintiff in this matter that she's going to be sued by them, or that they're going to seek recovery from her, and then now she decides that it's worth a while to participate. That maybe arguments along those lines would be arguments that could act as a savings provision. I don't have any of that in front of me at this time. What I have in front of me is a clear dynamic that the underlying claimant has failed to participate, not at one IME, but at 3 IMEs, and has simply turned her nose up, if you will, to the examination under oath, and has not participated. While there may not have been a subpoena, I haven't heard that there was one in that regard. Notification pursuant to the insurance contract provides a requirement to participate in an examination under oath should the notice of the same be given. For all of those reasons, it seems to me that the movement in this matter, the defendant in this matter, has met the burden as it relates to a motion for summary disposition. It does not appear to be any genuine issue of material fact upon which the matter can proceed, given that the underlying claimant failed to participate. For that reason, the court will grant the motion for summary disposition, and the matter will be dismissed on the motion for summary disposition. That is the order of this court. I'll sign the order consistent with the same upon presented. Madam Counsel, you received the address to present your order. Is that correct?
I'm sorry, what was that, Your Honor?
Did you get the address, the email address where you can present your order, ma'am?
I believe my assistant has it, Your Honor.
Okay, all right, very well. All right, thank you. Good day to both of you.
Thank you, Your Honor. Have a good day.
Yes, this young man, there's a young lady here, she has a small, I don't know if she left or not, she had a small claims case. She, people weren't notified, I wasn't here on that day, but she said she was here, so the plaintiff was here for that. I don't know if the defendant was here, but it wasn't an assistant, so. No, but she said she was here last on the 31st. I believe she's still on here.
I am also here for that file, Judge. Case ending in 898.
This is case number 21-240898. This is Michelle Maxwell versus Deneen, Detroit Realtor. That appears to be the pronunciation. It looks like this was set up for a creditor's examination at some point. All right, your appearance for the defendant, for who's Michelle Maxwell?
Yes.
All right. Good morning to you, ma'am.
Good morning.
For Dunyan, Detroit Realtors.
Kevin Callahan, P78273 on behalf of defendant Doyen, Detroit Realtor.
All right. So I don't have a file or anything on this. All I have is a register of action. So is this a matter, Madam, where you have, I see that a default judgment was entered on March the 9th of 2022. Then an order for seizure was filed. I see that subpoena for creditor's examination was issued. And that seems to be where everything stops. I do see that a motion for relief was filed. I don't have a motion in front of me. Counsel, did you file something?
I did. That's my motion for relief from judgment was filed. Your Honor, this matter began as a small claims case while we were going through an eviction proceeding with Ms. Maxwell. The eviction proceeding did resolve itself, but I filed a removal of this the small claims action on October 15th, 2021. Never received the removal back, never received any indication at all from the court. And then when I went to check on this, a default judgment entered. Apparently, according to court records, this matter was removed from small claims and placed on your docket. However, I was never listed as the attorney of record, never received the removal back, never received any subsequent pleadings or any notices because I was not listed as the attorney of record. So we are asking in this matter that we be allowed to file an answer and litigate this case, Judge.
So it looks like, to me, counsel, that the default judgment was entered in this matter in March of this year. And I didn't receive a motion until August.
Correct, Judge. I never received anything from the court at all. And 2.612 allows for an order or a judgment to be set aside within 1 year of the date of the default. So it's not a motion to set aside the default. It's a motion for relief from judgment, Judge.
Yeah, oh yeah, I understand that. Now, I wasn't talking about time frame. I'm talking about delay. I'm talking about delay, not time frame.
Yes, Your Honor.
And while you're correct that on the register or anywhere else, I don't have any indication that you were listed as counsel record, so you would not have received any notification, unfortunately. But I do see where Dundee Detroit Realtors have remained on this, and so they would have known that this matter was proceeding. They would have received some notification. But I do also see that there was an order for removal. The order for removal, it does not attach your name to that. As an officer of court, you're indicating to me that you submitted the document for removal, correct, sir?
Correct, yes. And as an officer of court, I would indicate to the court that my client indicates that they've never received anything on this matter either. So that's partially what contributed to delay here, that nobody knew what was going on at all. And now we're into the case.
Well, your client's address is listed on the register of action in Livonia.
Yeah, I would have to confirm that address. They're on 5 Mile, but I don't know if that's the address there. I would have to confirm that.
Because I'm seeing notifications of items sent out. So that concerned me. They're saying that they did not receive it. All right. So I see that the judgment was entered for $3,000 here. Is there any possibility that parties can talk about this and try to get this resolved? Because it's likely to be set aside, but it might be cost involved in setting it aside. And if the parties can talk about this and see what the bottom line is, see if we can resolve it first before I make the decision. Do you have any authority, counsel, at this point?
Yes, I can talk to Ms. Maxwell.
Yeah, so if you can talk about it, if I set it aside, you start at the beginning, there may be some cost involved in setting it aside. So Ms. Maxwell, I'm going to put you in a breakout room with the attorney on the other side to see if the parties may be able to talk about this claim and see if we could meet somewhere on this in terms of trying to resolve it. So you're going to get a notification from me right now that gives you the opportunity to go into a breakout room and talk privately about whether or not you can get this resolved. There you are, Ms. Maxwell, and counsel. Thank you, sir.
Judge, can I get the name of the defendant in that case?
In which case?
This one with Mr. Callahan. I have Detroit Realtor, but what is it?
It says Doyenne, is Doyenne, Detroit Realtor.
Okay, thanks. And the case number, last 3 digits is 898?
2124-0898.
Okay, thank you.
All right.
You granted this one you granted 892 for the summary disposition.
Yes.
So you
I
got it,
don't know.
huh?
I don't know.
Uh,
Yeah, the motion is granted, please.
oh, it's, okay, all right, okay. In the first case, that was a dismiss, right? I mean, that was a default for Mr. Cleveland, right? Mr. Cleveland, the first case. Mr. Cleveland, he got it with default.
Yes.
Oh, it was for the default against the plaintiff. Was it for the defendant? Yeah. Man. You gave me the five. Is this it right here? Oh, yeah, that's it, child. Yeah, that's what it is.
Motion. No, that's not.
Oh, okay, okay.
That- that's it.
Okay.
Yeah, can you read it?
Oh, I didn't know because I didn't see the file. Okay. Okay. What you doing? Ready to eat your food? Rod said it was chicken and noodles. She didn't say it to me about it. She didn't say it to me about it.
Judge, we're ready to go back on the record on 898. I don't know if the plaintiff might be still in the breakout room.
Hello? Hello? Am I here?
You're here, Ms. Maxwell.
Okay, I'm sorry. I'm on mute.
No,
It,
I think the judge is talking and we can't hear anything he's saying.
okay. Because I'm thinking, I'm like, I don't hear anything. Okay.
No problem.
Sorry, yeah.
Good. All
We're
right,
back
everybody
now.
hear me? All right. All right, we're back on the record in the suffix 0898 Maxwell versus Dunedin Detroit Realtor. I sent the parties out to discuss the matter and they returned. Go right ahead. Counsel, why don't you update the sir?
Of course, Ms. Maxwell and I did have a pleasant conversation, so I have a better understanding about what's all happening here. Unfortunately, I'm a little bit unclear as if the plaintiff does agree to reopen the matter. I don't believe that she does, so I would leave that to the court. I do understand that the court rules do allow payment of some costs if we were going to reopen it, and I'll also leave that to the court.
All right, thank you, counsel. Ma'am, anything you wanted to bring to my attention at this time, as there is a petition to reopen the case, and I've laid out some of the reasons and some of the reasoning behind that on both sides. Anything you wanted to say at this time, Ms. Maxwell?
Like I spoke with the attorney, I told him at this point, it's been just too much with that company. I just wanted to just get my money and be done with them. I'm not interested in a case. I don't want anything else to do with them. It's been going on now for over a year, and it was going on before he even became an attorney for them. And so I just want to just be done with it. Just collect my money and be gone.
All right, thank you, ma'am.
Because yes.
Are you done, ma'am?
Yes, sir.
All right, thank you. All right, the petition is brought before the court as a petition for relief from judgment. That petition allows the court to evaluate and assess why a judgment has been entered, not to address the underlying issue of whether or not there is the right to a claim. The issue of whether or not there is a right to a claim is not before the court. What is before the court is a procedural issue, and that is whether or not there is a basis for setting the judgment aside on reasons other than whether or not there is a right to bring the claim. What has been asserted as the reasons for relief from judgment is that the plaintiff, that defendant filed a motion to remove the matter to civil court, to general civil court. That matter was properly removed, and counsel raises the issue that he never received notice regarding this matter. Elsewise, he would have advanced the defense in this matter. There was the court would note that in looking at the register of action, that there was no further action taken by the defendant in this matter after the submission of the removal in this matter. The counsel, as an officer of the court, has offered before this court that he, in fact, is the one that removed this, and that on removing of this, had he received the proper notice regarding this case, that he would have appeared at the times that the court instructed him to appear. He did not receive that notice. I'm convinced of that because on the register of action, it still does not have counsel's address and information regarding this case. When he sent the motion for relief from judgment, that motion for relief from judgment triggered a hearing on today's date, and the counsel was notified because there was notification on that motion. Those are the kind of reasons that allow for the court to set a judgment aside, because the other side did not fail to respond based upon just inaction, but they failed to respond or to take further action because they did not receive notification from the court of the same. From the time that the petition to remove the matter was filed, every notice from that time should have been sent to Mr. Callahan, and unfortunately, no notice was sent to him. On the
Your
other
Honor.
hand,
Oh, I'm sorry. I'm sorry.
on the other hand, Ms. Maxwell continued to receive notice, and there is some likelihood that Dundee Detroit Realtor may very well have received some notification of the hearing as well. But it is counsel submission of a document that triggered his being the attorney of record in this matter. He should have received notice, and the court not sending him notice means that he would not be here, he would not know to be here, he would not appear because he had not received notice. For those reasons, I am going to grant the petition for relief from judgment. That will mean that the judgment in this matter will be set aside. The defendant, the plaintiff has incurred some costs as a result of the delays. Some of that delay is associated with the fact that the court didn't give the notice to the attorney. I have to believe that there was some notice that may have gone to the realtor company. What I'm going to do is I'm going to take costs under advisement. And as this case goes forward, I will ultimately decide what costs should be assessed as a result or as a part of setting aside the judgment in this matter. So the judgment is hereby set aside as the court grants the motion for relief from judgment. And the relief from judgment is conditioned upon costs that the court will assess at a later point as I'm taking it under advisement at this time.
Thank you, Judge. And will the court be submitting, drafting an order, or would the court like me to submit an order?
Mr. Callahan, if you will submit an order to the court at the court's email address, simply setting this aside, and the court's going to set a hearing on this matter, and the next date for hearing regarding this matter, 45 days.
So 45 for the 25th, 21st of November, or the 17th?
November 17th.
Mhm.
November 17, 2022 is the next action date in this matter. Any motions that the parties may wish to file or bring before the court, they can file those motions and set them for hearing on the 17th, so long as you give the other side at least 10 days notice of your motion prior to the hearing date. So if either party wishes to file something that you want the court to hear on that date, then you will file it and give the other side at least 10 days notice, and I'll hear it on the next action date. Also, I'm allowing the parties to discover information that may be under the control of the other party, meaning that if you put in writing a request for any documents, any information that the other party may have that you wish to have in your possession, that party must provide that information. If questions are offered, such as interrogatories, a set of questions demanding answers, if such documents are submitted, the parties respectively must answer those questions and return the answers to the other party. If requests to admit are submitted, meaning that a party sends a document saying, do you admit that such and such happened, that the parties mutually must respond timely to the request to admit that are submitted mutually in this case. And so I'll take another look at this on the 17th of November as a pretrial conference date. And if there are motions filed, I will hear the motions on that date as well. All right, that's the position of this case, and so the parties, you can exchange information, and I will address any motion type issues on the 17th of November 2022, and that's going to be at 9:45 a.m. 9:45 on the 17th of November.
Thank you, Your Honor. The only clarification I need from Ms. Maxwell is an updated address, because I still have the old address on Russell Street. I believe she vacated that property. So I just need a proper address so that I can serve her with any documentation.
All right, and you want to, ma'am, you can chat that address, or you guys can go back up to the breakout room, but we are on Zoom, and I wouldn't want anybody to get access to your address. So I'm going to give you a notification to go back and breakout room, you can exchange information so that you make sure you get the proper documents.
Thank you, Judge.
Right.
Appreciate that.
I do wish both sides well, and I await your order, Mr. Gallo.
Thank you.
Thank you. Now, go ahead, click into the breakout room, man, so you can exchange the proper information.